I have begun the video and the audio recording. This is for the deposition per the subpoena signed by K. McCoffey. At this time, I'm going to administer my admonitions, and then your attorney or yourself may administer your own if you so wish. You do have the right, of course, to remain silent, Mr. Wild. Anything you
Okay.
say can and will be used against you in a court of law. You have the right to an attorney. I see you already have one provided by the state of San Andreas. But as well as that, as an officer of the law, I do have to advise you of your Liebarger warning. Under Liebarger, while as a civilian, you do have the right to remain silent, and your silence won't be used against you in a court of law. If in an ongoing investigation or in a court manner or during deposition or testimony, if you choose to invoke your Fifth Amendment right, your peace officer license, and your ability to operate as an officer of the peace will be permanently revoked within the state and can only be reappointed by order of the governor or the vice governor. Now, having been advised of both your Miranda and your Liebarger warning, would you like to continue with this deposition and waive your Fifth
Yes.
Amendment right?
Yes.
All right. Additionally, I would like to advise you that while you may be questioned about some matters that fall outside of the prosecution window of 14 days, if you choose to perjure or omit facts for anything within the 14-day period or past the 14-day period, it would in and of itself constitute a new offense and be prosecutable under the law. Being made aware of this, would you still like to continue?
Yes.
I see. And at this time, do you have any admonitions that your side would like to declare for the record?
I do not believe so at this time.
I see. Well, I'll go ahead and begin with my questioning. Now, Mr. Wild, you're familiar with your standard operating procedure document?
I'm familiar with it, yes.
I see. And you're familiar with all aspects and how they are implemented within the Los Santos Police Department?
Not how they were implemented. That was above my pay grade. That was before we even came over. So
I
they were
see.
implemented by the commissioner and interim chief at that time.
I see. But you are aware of their current implementation within the department and how the department is following it currently, correct?
Yes.
I see. Are you familiar with Section 3.3 of the LSPD's SOP regarding the use of deadly force? And could you explain your own interpretation as well as HICOM's interpretation of that SOP?
For the use of deadly force.
Yes, Section 3.3.
I don't remember it by sections and stuff, but the use of deadly force is whenever you can use it whenever someone has a threat of serious bodily harm or death. You are to match class. So, say you're using a class one, I use a class one. Things of that sort.
I see. And specific to what you said about posing an imminent threat, is it an imminent threat to another person where they're not lawfully permitted to, or is it any potential threat? So if, say for example, they're driving in the opposite lane of traffic, would you be able to shoot that person with a class 2 just for driving in an opposing lane of traffic?
No.
I see. So it would have to be an unlawful threat immediately to an innocent person, correct?
Correct.
I see. And if there's not a imminent threat to a person and no other way to remediate the threat posed by them other than the use of deadly force, would those circumstances as listed there be the only allowances for the use of deadly force by a law enforcement officer?
I would believe so.
I see. And I know there are other certain examples, such as escaping prisoners and stuff, but that wouldn't fall within the LSPD's purview. That'd be the Department of Corrections. Now, could I ask you, are you familiar with Section 3.4 regarding the use of tasers by the department, and could you explain your and the LSPD's High Com's view on that specific section?
So tasers are non-lethal up until you get to, I believe it's lieutenant, then you're able to get a beanbag shotgun. Tasers are used to stop a threat that might not necessarily be life-threatening, but could cause bodily harm of any capacity. Um, I know, like during our 1070, in our 1070 SOPs, it is for you tackle twice, then you tell them they will be tased if they do not surrender, then you tase them, and then you give them X amount of time. I believe it's 30 seconds in between. Tase them again, and then you can go for cuffs. I mean, it's just the non-lethal, what a non-lethal would be used for.
I see. And are there certain restrictions beyond the time limit on which you might use a taser, assuming you are lawfully permitted to do so in that situation, such as can you tase someone off a building? Can you tase someone in water? Something
Can't
anything
tase
along those
someone in
lines.
water, no, not off of a building.
I see. And could I ask why you can't tase someone in water, even though it might be reductive?
I've just always been told that. I believe it may kill them. No one's really clarified. They just told me not to, so I didn't.
I see. All right. And could I ask, are you familiar with the LSPD's guidelines on shooting tires of vehicle when it takes jumps or when it drives off-road while not being an off-road vehicle?
Yes.
Yeah, could you explain that policy?
So there's been a new policy implemented where they changed it. I don't believe it's the code yellow, orange, and red anymore, but it outlines the specifics of what you need to have them set at the certain threat level because they're at that point a threat to innocent lives. So then you would react based on how these SOPs are laid out. I'm not really sure where he's put them at in here because he completely restructured everything.
I see, but you stated you're familiar with the SOP, so even though you may not know where it's at, you're at least familiar with the directive and the implementation of the SOP?
Yeah.
Alright. So in a circumstance where, say, a non-off-road vehicle, a sports car, drives off-road, would you shoot their tires?
Not the first time, but if they do it probably 2 to 3 times, then I would at least start a pit timer, and if it continues, then go for tires.
I see. Is it the LSPD's operating procedure that when a vehicle drives off-road and it's not an off-road vehicle, that an officer is permitted to shoot the tires?
I don't believe it's that at the very beginning. No, I believe there are, as I said, certain. I've not shot tires, and I can't tell you how long, so I don't typically do that
I see. Could I ask why you wouldn't shoot the tires of a non-off-road vehicle going off-road?
because all it takes is your aim to be off by a little bit, and then you risk severe bodily harm to the person.
I see. So, in situations where an officer following the SOP engages in that action in which you yourself said you would not engage in due to its potential lethal threat, would you, in some manner, consider that a bad practice?
A bad practice? No, it's just I don't practice it.
I see.
Most of the time I'm driving, so I couldn't shoot anyway.
I see. Are you familiar with the Department of Justice's guidelines on the shooting of tires?
The Department of Justice?
The federal Department of Justice, not the state level one.
Okay. No, as far as I know, as far as our LSPD guidelines, but not.
I see. Could I ask, as far as the LSPD guidelines, in situations where a non-off-road vehicle drives off-road, or in situations where a suspect, mm, there could be several other situations, but takes a jump of sorts, in either of those two situations, would it be permissible for an officer to shoot to kill the occupant of the vehicle specifically? Specifically the driver of the vehicle?
No, I believe for it to get to that point, it has to be where they are ramming officers, shooting at officers, things like that, to be putting the officer's life in imminent danger.
I see. Even though it may be reductive, could you explain why lethal force isn't authorized for a vehicle just taking a jump or just going off-road when it's not an off-road vehicle? Why is lethal force not permitted against the driver of the vehicle?
Because the only imminent threat to life would be of their own.
I see. So if lethal force wouldn't be justified in those situations, and the Department of Justice at the federal level, which binds all state, municipal, and constabulary law enforcement agencies, states that the shooting of tires is in and of itself considered lethal force, would your SOP not be in violation of federal law and statute?
That would appear to be the case, but as I've stated, I have nothing to do with these SOPs that were put in place and we were told to follow.
I see. You have quite a few SOPs in there. Have some of these SOPs transferred over from older versions of SOPs?
That is highly likely.
I
I'm not.
see.
I can't say for sure what he brought from the old SOPs, but you would have to speak to Commissioner Kelly in regarding that.
I see. Could I ask you, are you familiar with any LSPD protocols, anything in the SOP directives, or just any general common behavior exhibited by the police department regarding denying suspects the ability to call their own lawyer or to make any call altogether, including instances where LSPD officers contacted a lawyer on the suspect's behalf?
So what we are to do per our SOPs, it says they stay cuffed the entire time, so therefore they would not be able to use their phone.
I see.
So if they want a lawyer, we go into DOJ, the DOJ emails, as you know, and we ping for a lawyer. If they want a certain lawyer, we ping that certain lawyer. That's how it's been laid out to us from higher than anyone, even the chief. It came from the commissioner.
I see. And you are aware that the state of San Andreas adopted California common law, correct?
Excuse me, can you repeat that?
You are aware that the state of San Andreas has adopted California common law, correct?
Yes.
And under California common law, any incarcerated or arrested individual has the right to make not one, but three separate, free, and uninhibited phone calls of their choice, with at least one being to a legal representative.
Okay. As I've stated, this was not our doing. This came from above our department. It was a commissioner, so you would have to speak to him in regards to changing that. We just do what we are told
I see.
based on the premise that if we don't do as we are told, we are subject to punishment.
So since doing those actions would be in violation of the law, and you're indicating Lucas Kelly told you to do this actions, it is can be added together that you're saying that Lucas Kelly told you to do something which violated both civil rights and civil statute law?
That, if what you're saying is correct, then yes.
I see. And could I ask you what portion of the SOP covers and instructs officers on how to ensure and uphold the rights and civil liberties of detained and arrested persons?
To uphold the rights and civil liberties, I do not believe that there is a section specifically for that.
I see. So there is no section for that. Do you feel that that is an important part of policing?
I do.
I see. Do you feel that it's more important than, say, taser guidelines?
I would say they're probably of the same importance.
Of the same importance, I see. Do you feel there's any portion of the SOP which may be of a lesser importance than the upholding of the rights and the civil liberties of civilians while in police custody?
Um, I would say just off the top of my head, no, I wouldn't be able to name, but I would say there is some.
I see. And are you familiar with the LSPD handbook?
The LSPD handbook.
Yes.
I am not. That was something whenever I was BCSO that came out.
I see. In the handbook, I do believe it has a section about threat levels, and it indicates a Chief Plus for martial law. Are you aware of any protocols around that?
I'm not. We have, since I have worked here in beginning in November, we have not invoked martial law. So,
Are you certain of that?
not that I have been around for.
I see. And in the event that martial law would be invoked, why would the chief of police be the one invoking it?
I'm not sure. I didn't write the handbook, so I don't know why that would be in there.
Are you aware under the San Andreas civil law, Emergency Powers and Martial Law Act, that it specifically outlines that only the mayor of a municipality and the governor of a state may enact martial law, and that the martial law protocol listed within the LSPD's own documents is unlawful and could even be qualified as seditious?
I was not aware of that, but if that is what is stated, and I mean, that is a reasonable thing for the mayor and governor to be able to declare that and not the chief of police. So, yes. I don't know who wrote the LSPD handbook. Like I said, it was before we came back to LSPD.
I see. Are you familiar with your canine SOPs?
Not 100% as I don't actively participate in K9.
I see. Well, I'll skip all the questions relating to that then. Now, would I be able to communicate a photo to your attorney here so that he may communicate the photo to you?
Yes.
Alright, I have communicated the photo to your attorney.
Okay.
Are you aware of who the officer in the photo is?
I am.
And could you identify that officer for the record?
That's going to be Roy Thompson. He is a colonel
I see.
at LSPD.
I see. And are you aware of why Mr. Colonel Thompson would instruct other officers, including Brandon Jefferson, that a suspect does not have the right to call a lawyer or to be uncuffed when secured in cells, and why that he would even indicate they don't have a right to be uncuffed while needing food or water if EMS is on duty to come do a cell visit?
I'm pretty sure that they are, that is listed in our SOPs, that they are not to be uncuffed for the entirety of their time in cells until they are getting sent off,
So in
which
the
again would be above us.
so in the event that someone is starving and dehydrating to death, it is within SOPs, and Colonel Thompson there would have been following SOPs when directing officers not to unhandcuff individuals, only to call for medical aid when they starved or dehydrated to a near death or to a death state.
That would be correct. He would be following SOP.
I see. And you are aware that this is in violation of stated law under California common law that the state of San Andreas adopted?
I was not aware, but I do feel that that's fair. They should be able to have food, drink, whatever they need to survive.
I see. Are you familiar with what qualified immunity is?
No, I'm not.
It's a legal standard that agents of the government, including law enforcement officers, have protection from civil lawsuits as well as potentially criminal charges in the event that the infraction they commit, whether it be a violation of rights or a damage done, cannot be brought against them unless there is already a pre-established case law or a established law, whether civil or criminal, regarding the act.
Okay.
And you're aware that, given that several of the infractions and violations listed are clearly established in law, that officers would not be covered by nor protected by qualified immunity and could be personally civilly liable alongside the department itself for all of these infractions. And given the systemic nature of them, as well as the directed nature of them, could even go to a civil action lawsuit given their uniform defense nature against a wide range of persons.
Okay, yes.
All right. That's all the questions I have for you, Mr. Wild. Your attorney over there has the floor to ask any questions he feels he may need to ask of you.
I have nothing for Mr. Wild.
All right. Well, I suppose that'll wrap up the deposition here. It's the 26th of June, 2025, 9:27 p.m. Central Standard Time.